To start off understanding Section 62(1) of the Mental Health Act, it is important to look into the actual words of the legislation. That's what the law looks like. I'm just scrolling up and down on the web page to the law. Now this is enough to give most ordinary people a panic attack, and it certainly gives many doctors a panic attack, and many of them will say, I'm not a lawyer. The law is not interested in any of that. It's interested in it being applied, and ignorance of the law or lack of understanding of it is not an excuse for non-performance when we're talking about statute, which is the highest form of law in the UK. So this video will aim to get into this particular piece of law. Note that Section 62 is an exception to two important sections above, that is Section 57 and 58. So the usual story with legislation in the UK is that one then has to go and say, okay, well, what are those sections saying? And there it is. You go up to Section 57 and you have another panic attack, because what on earth does all that mean? For most people's purposes, we don't deal with this at all, right? This particular form of treatment. So stop the panic attack. And Section 58, which is the one where most psychiatrists and other mental health professionals will be operating. So Section 58 is about treatment requiring consent or a second opinion. Second opinion doesn't mean a second opinion from the consultant in the next ward. It means a second opinion approved doctor who's provided by the CQC. And you won't find the word CQC in here. So this is how the law is made, and they have the power and they can make it as they like. It's for us to ensure we get the interpretation correct. Else. Right, so one can spend a major part of their life trying to understand this. And it, curls back up into 58, 57 and all that stuff, right? And then you see here there's a little signposting saying that subject to Section 62 below. So it's signposting that where we started off in this video, that it was there, that some of these things apply, or exceptions and so on. And this registered medical practitioner is, again, don't ask me how, but it is the second opinion approved doctor from the CQC, shall consult with two persons and so on before giving a certificate, and that's a T3 in most instances, or a T2 on other occasions. But I won't go into T2s and T3s in all of this. It's just get bogged down and convoluted. The main point is that Section 62 creates exceptions, consent or a second opinion, and in particular, most of the time, the exceptions to 62 are here, right? Has consented, and blah blah blah. Okay, so it's an important thing to know that 62 is an exception to 58. And who are they talking about? The approved clinician in charge, right? Or a special registered medical practitioner appointed by blah blah. Okay, but the approved clinician is important in all this. The approved clinician is a term that sits by and encompasses the responsible clinician. So this piece of law is very special in the way 58 comes down on the approved clinician. And we're back at section 62. Right now I'm not going to go into each of these words. I want to get into a logic diagram that's coming up shortly that will show how these words become important, how they're woven together, and how the law applies a certain logic to it. It's their logic and they have the power, so we have to obey. And this is the logic diagram, and what this is doing is showing how these two words, immediately necessary, are applied to subsection 1a, 1b, 1c, and 1d. There it is. Immediately necessary, immediately necessary, immediately necessary. Okay. These are what we call truth functions in a logic diagram. Okay. And these are connected. Remember, we had immediately necessary appearing in the four of them, so that's why these lines are here. And this is an AND gate, which means something is going to come from there. That's very important, and we'll see how that works in a minute. So, for any one of these, if immediately necessary is not satisfied, then there are no powers to deliver any treatment. Okay. Responsible clinicians and approved clinicians should be very careful not to stretch the meaning of these words and seek legal advice where necessary. So let's say one wanted to prevent serious suffering. Serious is serious. The Act doesn't define what serious is, nor does the Code of Practice. But in making a determination on serious and immediately necessary, it's important to document all the relevant evidence very meticulously. So the applicability of the Act would flow from this being satisfied and coming into here. Okay. Now let's see what happens if these are not satisfied. Right. You can see that if this is not satisfied, powers are taken away from these three subsections. Okay. So it could be as immediately necessary as you wish, and the patient could be very seriously suffering. But if it is not irreversible, okay, this is not advice on what is not irreversible. I'm not here to list all the not irreversible situations. I'm explaining the law, and it is for each approved clinician or responsible clinician to ensure that they know that the intervention or treatment that they're going to provide is not irreversible. So I'm going slowly. There was a serious suffering by the patient. Patient needed immediately necessary treatment, and whatever it was that was going to be provided was not irreversible. That's why that is not a truth function. Okay, so that means it can't be done no matter what. But now let's say we're sure it's not irreversible, so we tick that one. What about if it was not hazardous? Yes, we get powers. Okay, but if it was not, the power is taken away. Okay, so this is a very intricate piece of legislation that takes years to understand, and I'm trying to show how these words interact to give or take away powers in the Act. What all this means is that very careful thought needs to be given to it when applying this piece of law, because remember 62 creates a specific exception, especially in immediately necessary circumstances. But there are other important words like serious, minimum interference. For non-lawyers, they may think, oh, who's going to interfere with the patient? This is just legal language, okay? Nobody in the law is thinking about health professionals interfering with patients. And the law isn't going to define what minimum means. It means to say, you as the practitioner, please ensure it's the minimum that you're doing. Okay? So we give you these specific powers to make an exception from Section 58, so use them carefully. That's what it means. But what does immediately necessary mean? Well, if one overthinks this, and I'm not going to do it, but some people tend to, as a way to try and massage what this means. Immediate means immediate. Immediately means like now, within the next few seconds, or within the next couple of minutes, or few minutes. But immediately can't logically or reasonably mean within the next few hours. But what one could argue, and I've seen these arguments, if we don't do it now, we're going to have trouble within the next few hours. That's how words get stretched in their meaning. It's possible to make a case that if one doesn't act now, there will be serious deterioration. And this doesn't say when, so it's possible that one needs to act now to prevent this. Okay. How an individual practitioner decides that has to be very carefully addressed and documented. Section 62 forms, electronic or paper forms, are tick box exercises, and they do not represent any form of real application. The forms are only evidence that it was applied. The actual application comes in the documentation. But in clinical practice, then comes a situation where one gave an injection of, say, haloperidol, and that's not irreversible, so that's fine. It's not hazardous, so that's fine. But there's no improvement within the next 2 hours. The patient is deteriorating further. What happens then? Can one write up some PRN haloperidol? And this is a very difficult area for those who have to apply the law properly. PRN means delegating to another person, usually a nurse, to decide when to administer the medication. My interpretation of the law, referencing section 58, is that this is the person involved. Section 62 is making a specific exception to this part of the law, and whilst it doesn't say that this responsibility here can be accepted and handed to a nurse, this is such a serious piece of law that if it doesn't say it can be delegated, it must not be assumed that it can be delegated. To understand the seriousness of all this, one really has to study very carefully in relation to the duties of care. Now, I return to the logic diagram. I could understand that some who have got to this point may be feeling confused, but the law is actually confusing to most people, so that's alright. It takes years of study to understand this stuff, and I'm just trying so far to make it more understandable, and I'm not guaranteed to do that. As a closing point, it also needs to be considered whether immediately necessary means regular medication. I suggest it does not mean regular medication. By the way, section 62 makes an exception to section 58. If a series of immediately necessary interventions happen, then it means these are adding up into regular treatment. No legal knowledge is required for that. That is the utmost basic of common sense. Section 62, I say, is not to cover for regular medications. And if that is happening in any place, then I say it is legally wrong. I would be delighted for an alternative opinion based on facts and interpretation of the law to tell me something different. So this is, in rounding off, an attempt to explain how the law operates with these various words that test what one is doing clinically, and I've shown that before. I've shown the exception to section 58. I've shown that it applies to the approved clinician or the responsible clinician. I've shown why there's no assumption to be made that the duty can be delegated, and I focus on the words immediately necessary. And before I leave, the word serious is important. And the next thing that is important is that the guidance from the Mental Health Code of Practice emphasizes how strict this law should be applied. Thanks very much.